No matter whether you are an employer or employee, you may find Korean labor laws to be difficult to navigate. Here at DRN AJU, we are committed to the purpose of providing timely and relevant information for use in the workplace, and this is the beginning of a series that reflects our commitment. This is the first episode of Did You Know?, a legal episode series that will impart information on various issues in the workplace. In this episode, we will talk about workplace harassment. We will break down what it is and what you can do about it. Before we start, here's a disclaimer. Nothing in this video is legal advice. It's for information and education purposes only, so let's get started. Harassment in the workplace has become a serious social issue over the past few years in South Korea. High-profile incidents causing public outrage were heavily covered by the press. New terms like teum and kapjil that refer to bullying culture and abuse of power were coined. As an attempt to put a stop to such misconduct, South Korea's Labor Standards Act was amended to include new provisions that prohibit workplace harassment. To better understand this concept, we will provide answers to some of the most fundamental questions. So, what is workplace harassment? According to South Korea's Labor Standards Act, workplace harassment is when an employer or employee causes physical or mental suffering to other employees or causes the deterioration of the work environment beyond the appropriate scope of work by taking advantage of the superiority in rank, relationship, etc. in the workplace. Those who are in violation of the above article shall be subject to an administrative fine not exceeding 10 million Korean won under Article 116(1). Harassment that takes place outside the office, in private residences, or even social media, for instance, can be recognized as workplace harassment. Then who is liable? Not only business owners and those responsible for the management of business, but also temporary work agencies and user companies are subject to the law. Even for workplace harassment that may occur between employees of user companies and temporary agency workers, user companies can be held responsible. Now let's address some preventative measures to be taken. Article 93 states that an employer who ordinarily employs 10 or more employees shall set out rules of employment regarding matters pertaining to the prevention of and response to workplace harassment. The employer shall also report such rules to the Minister of Employment and Labor. Failure to comply may result in an administrative fine not exceeding 5 million Korean won. Last but not least, let's go over some response measures to be taken. Anyone who has discovered the occurrence of workplace harassment may report the incident to the employer. Upon discovery, the employer must initiate a fact-finding investigation and take steps to protect the victim throughout the investigative process. Once the occurrence of harassment is confirmed, the employer shall take appropriate measures for the victim at his or her request and take necessary measures against the perpetrator. The Act ensures that no whistleblower or victim shall be dismissed or treated unfavorably. Such conduct by an employer may result in imprisonment with labor for no more than 3 years or a fine not exceeding 30 million Korean won.